released the terms and conditions of the settlement agreement that achieved all of the major goals that were sought when the lawsuit was filed. At that time, we stated to all of you that we would continue to scrutinize the steps that the trial court was required to take as a result of the settlement, and that we would continue to hold them accountable if they failed to follow through. And they have failed to follow through, and they continue to fail to follow through. We reported that the building was to be, quote, deep cleaned over the 4th of July weekend. That included things like desks, computers, keyboards, light fixtures, windows, door handles, blinds, railings, glass, and ceilings. The idea behind that was for the employees and members of the public who use that courthouse to come back to that new car smell and that new car feel, and improve the overall working conditions in the courthouse, and begin to develop the trust between the trial court and the workers going forward. As we all now know, the trial court leaders from Boston, who hired a Boston-based contractor to do the cleaning in the Western Mass building, did not hold up to their end of the bargain and utterly failed in their responsibility to deep clean. Instead, the trial court again tried to cut corners and shortchange employees and members of the public from Western Mass that work and use that important building and put their health and safety at risk by not actually doing a deep clean as required by the agreement, and actually not cleaning anything in a timely manner over 6 feet. The settlement agreement also required that the trial court begin the procurement process within 7 days for an occupational health assessment and evaluation. To date, almost nothing has been done by the trial court on this point, and people who work in the building continue to get sick and die from various forms of cancer, while the trial court leaders from Boston continue to ignore their duties and responsibilities that they agreed to in writing. The people who work in this building wanted and deserve information and answers as to why a disproportionate number of them are getting sick with serious illnesses in this building. And that occupational health assessment was the first step in that process. It's something that was verbally promised to workers many, many, many years ago and never conducted. And we got them to agree to it in writing as part of this settlement. The settlement agreement also required the trial court to inspect the roof of this courthouse, one of the main areas of leak, which leads to mold, and provide a written report by yesterday. And prior to yesterday, actually consult with the environmental committee in the courthouse and department heads in that building about the known tears, cracks, and leaks in the building. To date, the trial court has not even consulted with the environmental committee. Yesterday, we provided written notice to the settlement coordinator, John Payne, about these material breaches of the settlement agreement. He will then make a decision as to whether the plaintiffs in this case have alleged a material breach by not doing a deep clean, as we just discussed, and by not moving the procurement process along for the occupational health assessment in a timely manner. We intend to supplement that notice today to add information related to the breach of contract and settlement agreement related to the roof. Given the facts that have already been brought to the settlement coordinator's attention, the facts and the pictures in the videos that were given to the media yesterday and made public, we are very confident that he will decide in favor of the plaintiffs and the workers in the Western Mass community and schedule a mediation with the trial. May require another shutdown of this courthouse because it is simply too disruptive and not safe. And the plaintiffs never agreed to have the deep clean take place while people are working in the building. Unfortunately, the cavalier approach by leaders from Boston and the trial court is simply disrespectful to Western Mass, and it continues to frustrate all of us. We will all continue this fight for what will hopefully lead to a conclusion that investing in a new and improved and modern courthouse in Hampden County, and we will now take any questions that you may have. They were supposed to start the procurement process approximately, I have to look at the agreement, approximately a week after, what's that? 7 days after the settlement agreement was signed. To date, we have no information that that procurement process started.
And just to add to that, the only thing that we do have was there was an email sent out in the beginning of June that the trial court was talking to various groups, including the AG's office, to make sure that they were doing it correctly. However, there's been no update since that, and I know no one has actually seen a request for proposal that's been sent out for that occupational health evaluation.
The procurement process is looking for someone.
Correct. The procurement process is the first step that DCAM and the trial court has to go through, just like everything else. So they have to set up what's called a request for proposal, where they outline what they want, and then they need to send it out for a certain amount of time for people to bid on it, and then they select based on the bid. And again, to our knowledge, that RFP has not been sent out, and no one has seen it, either from the environmental committee, the department heads, or the plaintiffs.
The people you're representing, are any of them going back to the courthouse at this time?
We spoke briefly with Cheryl yesterday. I think she spoke to many of you. She is not going into that courthouse as of yet. She was looking forward to going back in September once the filters were placed on all of the vents. But as of right now, she has no faith in the trial court, and she's not sure if she's going to be going back.
7 days from when?
7 days from May 6th, when the settlement agreement was signed.
So obviously now you have to bring it to the settlement coordinator, but what are some consequences if they have not met the
So under the terms of the settlement agreement, the settlement coordinator needs to look at the allegations that we've made and in all likelihood schedule a mediation at some point within the next 14 days with the trial court. And if the matter does not get resolved at that mediation, then the plaintiffs have the opportunity to pursue litigation again.
chances this can go back to the court?
Absolutely.
And just to clarify, the case will be brought in Hampden County Superior Court, not in Boston. A venue choice was placed into the settlement agreement.
The pleading terms that was brought in here, picked by the trial court, do you guys wish you had more say in who got to be going in this court?
You know, I don't think it's necessarily the cleaning company itself that was chosen. I think it's the trial court it's picking the vendor. It's not really the vendor. It's the trial court's supervision of the vendor. It's our understanding that the contract between the trial court and the vendor, from the people that we spoke to, including employees that were actually doing the work, that they were not even cleaning anything over 6 feet, and that what they were doing, what they told us they were doing, was not really a deep clean, but it was more like a surface clean. And when you see the pictures, you see the videos, you talk to the people in there, even if it was a surface clean, it didn't meet the standards. It didn't meet the standards of the agreement, and is not the expectation that the plaintiffs, the courthouse employees, or anybody else had with respect to what was done in there. Haven't been able to confirm it, although I've seen reports that it was in the range of $35,000, and I've heard this morning that the cleaning crew consisted somewhere between 10 and 20 people.
Do you think that's adequate for the size of those?
Obviously not, given what was done. I mean, if you're doing a deep clean, things need to be moved. You can't have, for example, in a library where books have been sitting for decades, if you're going to do a deep clean, you need to move the books, right? I mean, it's no different than if you're cleaning something at your house. You've got books that have been on a bookshelf. When you go through and you do your spring cleaning or your fall cleaning, you move that stuff and you dust under it, you clean under it, you disinfect under it, you do what you have to do to actually clean it. You don't surface wipe around it. I went back in the building this morning just to double and triple check, and I went up to the library, I moved a couple of books, and it doesn't take any type of expert whatsoever to realize that those things weren't moved. and those shelves were not really clean. And if you take a walk through, I encourage you all to just walk through that building, go into the elevator that I went up and down this morning. Take a look for yourself. Take a look on the walls of the elevator and see if it's clean, right? It's obvious. It's obvious that a deep clean was not done. And for the trial court, if they did sign off on this, it's just unacceptable. Any other questions? Thank you all for coming.